Berapa itu Pak biayanya?
Supplementary list? I don't know.
Yes, Mr. Kinji. So, 202. I think this bench might not be available, regularly. So we'll post it before the next bench. As well. Yes, I request the party to the matter after 2 weeks. Or weeks. Let me know for sure, yes.
Lordship, all the three matters are
What the interconnected?
all the three matters, yeah.
Yes, also. Like musical chairs.
Supplementary list, item number 1.
Is it? What is this, Mr. Dev?
Please, Your Lordship. Lordship, this is a PIL where we are aggrieved by the.
Let the file. Yes.
So this is a PIL, my lord, where we are aggrieved with the appointments of teachers made in the East Garhwal district without having MTET, my lord.
Who are you?
Lordship, I am a resident of East Garhwal. This is
You're
a
a
PIL.
field candidate.
No, my lord. I have had certain qualifications, but I am majorly aggrieved by the lack of poor education, my lord. Schools are not being
Lack
run. Lack of
poor education?
I'm sorry, my lord. Lack of good education standards.
Lack of good education,
Yes, lack
okay.
of good education standards. And my lord, since this is a appointment made dehoes the statutory rules, the PIL would be maintainable, my lord.
Why do you say those statutory rules?
Because, my lord, MTET is a mandatory requirement under the RTE Act, and all schools have to adhere to that. And even rounds of litigations have gone through this honorable court also, my lord, where it has been held that MTET is a mandatory requirement. Despite that, my lord, advertisements have been issued without requirement of MTET. Recruitment process has been carried out. Appointments have been made and approved in substantive posts.
Are you advocating the appointment of some other people or no?
No, my lord. I am only aggrieved by their appointment, which is
Yes. Yes.
Noticing that government is one thing that few numbers of persons are responded here. Individual cases.
So, you made them party individually?
individually.
These people who
are supposed to have been appointed, dehouse the rules.
As well as the concerned managing committees.
Because the other thing is that that is our doubt, with regard to maintenance of the PIL.
Lordship, I can
Advocating the dismissal of these teachers or questioning them. Then with regard to service matter, then
Since I understand much, but if
Yes.
it's I'm seeking for a writ of quo warranto, the appointments
what
are
go
made.
on to? Do you mean to say the government is not adhering to the norms?
Lordship, yes, because they are approving the appointments made without MTET. They are approving advertisements made without any requirement of MTET.
Let notice be issued to the private respondents. In the meantime, Your Lordship, I'll seek instructions.
On the maintainability also
Or
we can hear it also.
hear on the point of maintenance.
That must say that issue notice returnable in 3 weeks. Stop. We won't issue a notice to the private respondents. Let the government only come first. Yes. Issue notice to the state respondents presently. MST Young England AAG assisted by so and so present accept notice. Stop. This is the matter after 3 weeks for instructions to affidavit. We won't issue notice to the private respondents right now.
Much obliged, Lordship.
Item number 2.
This one? Yes, who's appearing this matter?
May I please, Your Lordship? My Lord, this case is come on transfer from the High Court of Manipur pursuant to the direction of the Honorable Supreme Court, my Lord.
Yes. Now bench is available.
Yes, my Lord, but as it has been transferred by the Supreme Court, it has to continue. And it has already been
You
heard.
can go back and make another request.
No, Lord, it
Go back to the right.
it has already been substantially heard by the Honorable Court. On one occasion, it was about to be disposed of also, my Lord. My Lord, may I take Your Lordship to only one of the order passed by Your Lordships on the last occasion. This speaks the whole case, gist of the case is given therein, my Lord. My Lord, the order dated 4 October 2023. This was passed by this Honorable Court, my Lord. It gives the gist of the whole case, my Lord. Shall I read, my Lord?
Yes. What does it say? Sum and substance?
My Lord, Your Lordship, can you see? the order dated 4th October 23. In this appeal, which has been transferred to this court pursuant to an order of the Supreme Court, the judgment and order impugned was passed on a writ petition filed by appellants questioning the propriety of the dissolution notice of September 29, 2021 issued to the college which the appellants are associated. When the appeal was taken up in right earnest for the first time on August 31, 2023, a prima facie view was expressed that neither the impugned judgment nor the impugned dissolution notice of September 29-21 could be sustained in law, as notice of dissolution appeared to be contrary to the provisions of the Granting Aid Court. It was in such circumstances that the state of Manipur, whose caused the notice of dissolution to be issued, was afforded an opportunity to take remedial measures at the behest of the state. The time for such purpose was granted till September 4, 23. When the matter appeared on September 4, 23, the state indicated to the court that an order had been passed on September 1, 23, by which the impugned government order of September 29, 21 pertaining to the dissolution of the governing body of Naram Bihari College, Khundrapam, had been cancelled. In the order dated September 4, 2023, the operative part of the order of cancellation was set out, and it was observed that the appropriate consequential order from Director of University and Higher Education would follow. It was also recorded that as a consequence of the cancellation of notice of dissolution, the governing body of the college stood restored. It, however, transpires that despite cancelling the notice of dissolution of September 29-21, a subsequent steps taken by the state in effect negated the impact of the order of cancellation of September 123. The appellants complained that despite the order of cancellation, the governing body was not allowed to function, nor was it recognized to have been restored. Applications have been filed for contempt. The state sometimes says that there is a good explanation to justify how the state acted after issuing the order of cancellation. Prima facie, it appears that the state may never have been interested in effectively annulling the illegal notice of dissolution of September 2021 to restore the governing body of the college, for such governing body to continue to run the education institution. This would make the act of the state an act of contempt, as the state may have deceived the court into believing that a state of things had been brought about without such things state of things being put in place. Accordingly, since the state seeks time to explain its subsequent conduct, it has afforded a fortnight to file an affidavit in such a regard. All such taken by the state subsequent to the order dated September 4, 2023 will abide by the result of the appeal and may be scrutinized in this appeal, particularly considering the state's representation to the state as recorded in the order dated so and so. So, Your Lordship will kindly appreciate that this honorable court gave them liberty to take corrective measures, and they in fact they issued an order cancelling the dissolution order, my lord. But thereafter, immediately thereafter, my lord, this honorable court specifically observed that our governing body stands restored.
Should be restored, yes.
Restored.
What happened after?
But in spite of that, they have issued an order nullifying the
Where's
entire.
that
My lord?
Where's that order?
Yes, my lord. My additional affidavit, my lord.
File done?
Additional affidavit.
Third of October.
Yes, my lord. Yes, my lord. Well, it may take your lordship to additional affidavit, my lord, dated 29 September, my lord.
This one filed by.
The state has also filed their reply, but my additional affidavit is dated 29 September 23, my lord.
Okay.
Got it, my lord?
Yes, yes.
My lord, I take your lordship to their order, my lord. Your lordship, first may I take your lordship to page number 19, my lord. This honorable court's order, page number 17, my lord. 17.
Yes.
Prima facie, upon hearing both the appellants and the state, it doesn't appear that
You should just see the order of the
Yes,
respondents, whereby he said they have.
Yes, my lord, my lord.
Yes.
My lord, page
False
number.
contempt, yes.
My lord, page number 31. This is a typed copy, my lord. And the order issued by the director is later, my lord. This is a lengthy order, my lord. May I read the 11th portion, my lord?
Yes.
Page number 34. 24.
Yes.
And whereas the said order dated 2/3/21 is an order issued in non-compliance and violation of the interim order, court's order dated 18/12/2020, the order the order and action constituting the governing body on 2/3/2021 is an invalid order, as the said order is also a result of other invalid action undertaken by Sri N. Sitaljit Singh, while it is well known that an invalid action or order can only generate an invalid order. Further, an order invalid since inception cannot attack principle of natural justice in making a declaration to that effect. And whereas nobody can be allowed to take their unfair advantage by committing breach of an interim court's order and escape the consequence thereof by pleading misunderstanding and thereafter retain the said advantage.
So their stand is that there was an interim order in 1812 and a governing body constituted in violation of an interim order. And that is why you cannot be restored.
It has not at all, no relationship at all. I take your lordship to
have to the instant dispute.
My lord, I'll take your lordship to the interim order. Your lordship can kindly take see the interim order, my lord. It is nothing to do with the present. They are trying to IVAS. Your lordship can kindly see, first of all, let us see the writ petition in which the interim order was passed.
Let's not just show the where's at 1812. Then we will ask them why.
First, your lordship may kindly see the order which was the writ petition in which the interim order was passed, so-called interim order was passed. Page number 50, my lord.
Of this affidavit.
Yes, my lord. This is an affidavit. I have annexed the entire writ petition as well, in which interim order was passed. Well, page number 51. Issue a writ of certiorari or any other appropriate writ or direction of the like nature, quashing and setting aside the imperial order dated 27/11/2020 and its consequential action and extra 15 is illegal. This order is 27/11/2020 is also have annexed, my lord. Your lordship may kindly see that is at page number 36, my lord. Page number 36. Back, let's go back, my lord. Page number 36. This is the order which was challenged before in the writ petition. Nothing to do with the governing body.
Page 30?
Page 36.
Okay.
Whereas it has been directed to initiate necessary action against Sri N.G. Kasni Devi, Principal, Naram Birhari College, for the alleged financial mismanagement and irregularities in appointment by Director so and so. Whereas a committee consisting of Sri O so and so, University so and so, Legal Higher Education as member have been constituted by order number so and so to conduct an inquiry into the charges level against Kasni Devi.
1812-2020. They're placing reliance on the 1812-2020, page 53. They're taking reliance. They're relying on 1812-2020 to say that your committee is legally constituted. Correct?
My lord, this your lordship may kindly see page number. The interim order is page number 53, my lord.
Yes.
In the interim, the order dated 27/11/2020, issued by the chairman caretaker governing body Naram Birhari College, Manipur. This is the order I am reading, my lord, page 36.
Right.
So this 36 is the only regarding suspension of the principal, nothing to do, my lord. And apart from
where
that,
we stand now. What have they filed? What have they sent in the affidavit? They
said nothing. They have said nothing. They have only reproduced the orders.
Appearing for the state.
I am appearing for the state, Lord. I am appearing.
One more thing, my lord. Not only that much, my lord. Not only that, they have issued yet another order, my lord. On 18th, your lordship may kindly see. That also have annexed page number 61, my lord, of the additional affidavit. They were not said.
You file contempt in this matter?
Yes, my lord. It is listed today, my lord. Listed today. My lord, page number 61, my lord. Page 61, this is the order which was yet, they were not satisfied with the 12th order, my lord, the earlier order which I have read out. Now they issued another order, my lord, hereby restoring all the orders that was, my lord, that was issued after dissolution. And you also may kindly appreciate that the learned single judge judgment was suspended by the Honorable High Court. Still they are continuing with all the orders that were issued pursuant to the learned single judge order. Though it was suspended, my lord, it is already suspended. You also may kindly see at the time of edition of the appeal, it was suspended. Contempt after contempt, my lord. Violation after violation.
What have they said in the affidavit?
They only reproduced the orders. Nothing else. The orders which I have annexed in my additional affidavit and my writ appeal. Nothing else.
You don't need to rebut the affidavit any longer?
Nothing, my lord. They have said nothing. They are simply trying, they have nothing to say, my lord. They have only reproduced. Let them say, my lord, how they justify it. It is a clear case of contempt, my lord.
You have a contempt listed today?
Not only deceit, but they have, the Honorable Court has held. The Honorable Court.
May I reply, Lordship? My learned senior is over. Lordship, at the outset, I would like to make a humble submission that the facts as disclosed by the appellants are not correct on record, Lordship. The appellants are choosing a method of pick and choose of certain paras and leaving out the pertinent portion in which the orders has been passed. The first part is that, Lordship, in the contempt petition, no notice has been issued. notice is yet to be issued, because the Honorable Court was of the opinion, I believe, when the contempt was moved, of the opinion that when a direction was passed by this Honorable Court to act, to pass an order by the court, by the government, to correct or take remedial actions, is or not and. In that matter, if a direction, compliance of a direction passed by this Honorable Court amounts to a contempt, Lordship, it will be against.
No, that's not the point. The point is that remedial measure, or to take remedial measures means you take a measure.
Yes.
Because prima facie, if I understand the order read by Mr. Sahu correctly, is that the court was prima facie satisfied that the single bench order had to be set aside. You had a prima facie case. And if you were the government, your state respondents are given the opportunity to take remedial actions, and by one hand you take remedial action, other hand you seek to take it away again, won't that amount to playing with the court?
No,
it's not only a question of it's not a question of saying that the order of the court is there, we have complied, will that amount to contempt? No, will it amount to you say playing with the order of the court. If it's found that you playing the order of the court, then you'll have to face the consequences. That's all.
Lordship, I may
simple as that.
Lordship, the basic crux of the matter is that, Lordship, when this matter came up after transfer from Supreme Court, the matter was listed for argument on 14th of August. The sequence of events, Lordship. Lordship.
I've not had the opportunity to really look at the file.
Lordship.
See, there's only.
Lordship,
from what I understand, that it looks like there is some you're playing the orders of the court.
It's not a case of that, Lordship. The fact is that, Lordship, my friend is saying today that no contempt of court, the order of the single judge passed in a writ court, staying the operation of an order where the principal was ousted, Lordship, from his post of this college, was stayed by the High Court, has no relevance to the present proceeding, then I have no case to settle, Lordship. But the Manipur Education Code, by the virtue of which this private college, this aided college is governed, provides that the principal acts as an ex officio member of the governing body which is constituted in terms of the Manipur Education Code. He plays a vital role. He plays a vital role in the sense that he is the one who organizes everything, sits over the this governing body, and ensures that the new governing body is constituted. The principal who is to act in the constitution of the governing body, which is now declared null and void, is the principal who was reinstated to the position by virtue of the interim order. She was not made to act. Dr. Ikasini Devi was the principal at that point of time. By virtue of a order passed by the caretaker governing body, she was ousted. The Honorable High Court stayed that order. What is the implication of staying of the order, Lordship? She goes back to the same position, Lordship, where she was, status quo ante, Lordship. If it's a case of status quo ante, how could the clients which my learned friend is representing, the principal, continue to act, Lordship, despite the operation of the order, the interim order being extended from time to time? That means there was a gross violation of the interim order. Now, the state government, the concerned director wrote a letter to the law department. What are we to do in this present situation where the court order has reinstated the position and Sitaljit, this concerned person, continues to exercise the power of principle and had constituted the...
Even then, one thing by your submissions also,
Lordship.
Sorry, with due respect, is that is the state is going to try to overcomplicate the issue.
No, Lordship, the
basic, see, from where it started, if the order is unsustainable, it ends there. If the division bench, the bench before us, was satisfied that prima facie case was made out, we will examine it.
This
the Panam, you are appearing for whom?
Lordship, I am appearing on behalf of Resolution number 5, my lord.
Yes.
Lordship, I filed one MC case, Lordship, which is listed today, MC 41.
Regarding?
And in MC 41, it is filed under Section 151 CPC, making a prayer for closure of the present writ appeal in the law laid down in the Shipping Corporation of India, my lord. Because the Lordship, cause of the writ appeal, Lordship doesn't survive because the order impugned before a learned single judge, which was This was, Lordship, the writ petition was dismissed against which the appeal comes up. Lordship, having cancelled by the state government, Lordship, issue raised in the writ appeal no longer
So you
exists.
see it's infructuous.
That is Lordship. Lordship very clear. And the subsequent order, Lordship, the grave Lordship, it is open to challenge before any appropriate forum. That is another thing. And the Lordship was referring to page number 53 of my learned friend edition affidavit. In that case, my learned friend was submitting that there is only connection with the governing body which he represents and the present case, Lordship. What happened, Lordship, as per the Manipur Jurisdiction Court, which my learned friend just submitted before Lordship, that constitution of a governing body, it is to be initiated by the ex-officio secretary. That is a principle. There was a regular principal, my Lord, Dr. Ekasini, and he was placed in the suspension by the ad hoc committee. And the Lordship suspension order was challenged. In place of the suspension order, one Sitaljit was appointed as in-charge principal. That was, Lordship, that was challenged and that was stay. In spite of order of the stay, Lordship, then this Mr. Sitaljit acted and the proceeded to constitute.
Now you're the president, principal in charge.
Yes, he was the only principal. The moment, Lordship, his appointment is in charge, Lordship, is stay. The order as a whole, the appointment of Sitaljit as in-charge principal after the suspension of Dr. Ekasini. If that is stay, Lordship, then original principal come into play. She has to restore in a present position. She is to act for the constitution of the governing body. But what happened then, Lordship, by using the power corridor at the relevant point of time, Lordship, he exercises the power without having an authority in the constituted, and after constituting government has given the approval date with the constitution with by his name as a official secretary, Lordship, that was constituted, letter was given. Subsequently, Lordship, when they realized that there is an interim order, there is a sense that in place of his name as in charge, Lordship, that was replaced by another order, the principal or in charge principal. Lordship is fully aware that any action taken in violation of the interim order as held in a review case, it is a nullity in eyes law. Somehow, Lordship, unless it is pointed out, it remains. Once it is pointed out, Lordship, law opens its eye, my Lord. That is the situation. And the Lordship, what I am submitting in my misapplication, that Lordship.
There was a prayer.
Yes, I said that, Lordship, the read appeal be closed.
Appeal number 20
Right.
and factuous.
I am ready to, Lordship, this notice is not yet issued. I have sub-copy long time back to my learned friend in October. He hasn't given an affidavit in reply to this. And of course, Lordship, notice is yet
No,
to
but
issue.
even then, Mr. Pawana, when the writ appeals answered, this will cover this question.
Yeah, right.
So because it's all part and parcel of
Yeah,
the same
right.
thing.
But the thing,
And
Lordship,
I think it is since we just
other Lordship, this subsequent order, my learned friends submitting before Lordship that it is contrary to the direction by the liberty given to the state government by this honorable court. Liberty given by this honorable court, they have exercised. State government has
That
exercised.
is what we are concerned about, Mr.
They
Pawana.
exercise, Lordship.
That's what we're concerned about.
After
If we
exercise,
have the feeling or
I may be allowed to complete, Lordship.
somehow
After
the
exercising,
orders of the court be
I'm saying
frustrated
that after
in the
exercising
backhand.
power, Lordship,
Lordship, may I
if they
just
think
make
that,
one point I just want to add.
if they think,
Yes,
if they think that, Lordship, there is a contempt.
You will have your chance to speak. Let him finish.
Lordship, if they consider that the Lordship, subsequent order is an act of committing the act of contempt, Lordship, it is open to them to pursue the contempt process. But Lordship, my humble submission, Lordship, that subsequent two order, if they agree, it is open to them to challenge it before appropriate forum, Lordship. And these two order, Lordship, perhaps, Lordship, I'm sorry to say, this court doesn't have any jurisdiction. That
Yes,
subsequent order.
absolutely. But since it's all part of the same list, so maybe it stretches there
Yes,
also.
Lordship, Lordship may be that two subsequent order.
Of course.
Lordship, it is an order, Lordship, it is an order to nullify the order passed by this court. This order has never given in the order that the Lordship, this governing body, which my Lord and friends represented, they should not be dissolved. That order should not be interfered in any manner. That there has never any direction, Lordship. If there is such a direction, I can understand. Only liberty was granted to take remedial measures.
That is why Mr. Pawana
Yes.
feel that, on the liberty that was given,
Right.
instead of making it, sanitize it and make it cut and dry. Other orders have been passed which has further complicated the issue.
Yeah, right.
And
I
maybe that
understand.
raises
I
a
understand
cause
this
that
situation.
raises
But the Lordship,
doubts in the minds of
but
the court.
understanding this situation, legal proposition involved.
I just want to. The submission.
how? I think,
Their letter, just one letter, which clarifies everything. Their own letter. I have annexed this give replies to that contempt order, that order, stay order, and then suspension order. This give replies their own letter. Page number 94. Only one. Only
affidavit.
I need only one of my additional affidavit. Only this 93, 2 pages. The type copy. They themselves say, Your Lordship, this is by the government of Manipur. Now they are blowing hot and cold, my lord. Your Lordship, kindly see. This is very short letter. Can I read, my lord? Page number 92, 93. This is very important matter, my lord, because they have played with the court. This is a fraud on the court, my lord. Your Lordship, this has been observed by the court. That it is a deceiving. They have deceived the court. It has been observed on the last occasion that the court has been deceived. Page 93, my lord. Court has been deceived. Your Lordship, page number letter dated 14 January 21, my lord. Page number 93, my lord. Got it?
93 of
Yes,
the
my lord.
affidavit.
93 of the additional affidavit. Sorry, my lord. It is their affidavit. I'm sorry, my lord. My affidavit. Where is it? Additional affidavit.
The last affidavit.
Joseph,
yes. They have,
I wish I had some more opportunity to submit. In fact,
No, we're not closing the matter today. You see, the thing is that this.
Lordship, where is the problem coming, Lordship? That is what I wanted to identify. Lordship, the matter was never heard at length, Lordship. The matter was not addressed. Only the issue of violation of principle of natural justice was looked into because the learned counsel for the appellant only raised the issue that principle of natural justice has been violated as pre-decisional hearing has not been given, though post-decisional hearing was given, Lordship, as directed by the Honorable Court also to dispose of the two representation file as a post-decisional hearing, Lordship. Full opportunity was given. Direction, as per the direction of court also. Despite that, they did not show any prejudice being caused to them by giving a post-decisional hearing instead of a pre-decisional hearing, Lordship. Now, the issue, when this matter came up before the revision bench, when I appeared, Lordship, I was asked, when an order is struck down for violation of principle of natural justice, the merit of the case is not gone into, Lordship. Only the issue is kept open and the order is set aside or cancelled only for the reason you have violated the principle of nature. I bow down before the court. Okay, I will cancel this order, but I will keep my remedy open. I said before the court and is
that is what we have to examine. That is what we have to examine. That's the only thing.
And I said we will keep the remedy open because once the principle of natural justice, if it is said to be violated, doesn't mean that the merit has been gone into. That issue has to be kept into because a new governing body has been constituted. They are functioning. They are not a party to the proceeding. Now, in this situation of the matter, the writ has become infructuous because after the post the decision, hearing of the post the decision.
Page 57 of my additional affidavit.
It's only one
For the last one,
you take a date, we'll hear it.
Only one sentence will make the whole thing clear, my lord. They have written a letter, my lord, to the director saying that till Ekasni Devi is restored, the in charge principal will be holding. There only one sentence, my lord, I read out. This is their order issued by the government to the director.
With that we'll look into. I've given in my affidavit. I've clarified also. I've clarified. You have to read the whole affidavit.
I want to read their own document.
Affidavit, not a part of the
their own document. My lord,
clarified.
My lord, Your Lordship.
On examination, seen the affidavit filed by additional affidavit been filed by the state respondents. That's also. We'll pass a common order for all the cases. That's also
Contempt petition.
Contempt may not be issued.
Contempt
matter is
one issue contempt right now. We just
examine
the matter.
It is already been observed that contempt has been made out. It has already been observed that contempt has been made out prima facie.
Please listen to the order. Yes.
My lord, they are interested in delaying because they are holding the post.
Please listen to the order. Yes.
But they are enjoying.
It's under some constraints. So anyway, so that we will we hear this matter. Short date will give you. Yes.
Let it be next week, my lord.
Affidavit. When did you file the affidavit?
I have filed it in time, Lordship, on 17 October. My junior flew over.
Yes, affidavit has been filed as by state respondents. Yes, which is registered on 19/10/2023 for this court stuff. And Miss Case, on behalf of Honorable Five, noted that a Miss Case being when you see number 41 of 2023 has also been filed seeking dismissal of the writ appeal on account of it being infructuous stuff. It is also further noted that in view of the orders passed by this court, contempt. You filed contempt application for the second
Yes,
number?
my lord. Number 26.
Yes, number 4. Yes, sir. Contempt applications have been filed by the appellants, which has also been listed today. So all these matters for further hearing on. You come prepared. We'll come.
On 13th, my lord.
Lordship, no, 13, up to 15, I'm not available, Lordship.
Then 16,
Lordship may have on 17.
It's on 17.
My lord, for final disposal, my lord, because they kindly observe, my lord.
You understand the mind of the court? The only thing is that we don't know. Court likes the orders of the court be played with, and if that is detected or discerned,
Yes, yes.
as contained from the early order, then that is
I'll satisfy my.
that is why we give you a chance to satisfy. We'll go through your affidavit. That's why we give you a
I've
chance
shown
to
the affidavit, Lordship.
satisfy. That's why we give you a chance to
Even a detailed
satisfy.
affidavit running
With
to
Prampas
Lordship.
High, what it appears is that
Lordship is.
that what you given with one hand, you can give
111
it by the
pages
hand.
affidavit I have filed, Lordship.
My lord, they have committed fraud on the court, my
No,
lord.
no,
They
no,
have not observed.
it's the party who are violating the order, Lordship.
Yes.
Obliged.
Any mention?
May I please, Your Lordship? My Lord, I beg to mention from the hearing list, my Lord, item number 28 and 29. These are analogous matter, my Lord.
This is from the
Hearing list, my Lord, Diri. My Lord, here Lordship has permitted the state respondents to bring some additional documents, my Lord. There was some clarification sought by this Honorable Court. So, my Lord, the affidavit is yet to be filed.
So I've been regularized by the cabinet, Lordship.
My Lord, this is a lapse post, my Lord, which we say it lapsed after the last person retire or demise, my Lord.
But he said he's recognized by the cabinet.
No, my Lord, his name has been approved by the cabinet. So, my Lord, that there is a condition also if there is a sanctioned vacancy also. That also aspect has to be looked into by the department.
When you after 1 week?
My Lord, within 1 week we'll be able to file the affidavit.
MS Ark only. Please, sir, Matthew adjourned and enable her to file the affidavit as allowed by this court on early occasion. At least after 2 weeks. Yes.
Highly obliged, my Lord. 28 and 29, my Lord.
But please, Lordship. Item number 17, Lordship. I need 2 weeks time to just to take instruction from the client.
Item number?
17.
2 weeks time.
Lordship, because I received affidavit very late. Only 31st only they given me the copy of the affidavit.
At least up to 2 weeks as paid by.
All right.
As requested by the counsel of the petitioner after 2 weeks. Yes.
I beg to mention item number 16 of the mail list, Lordship.
This matter has been adjourned too many times.
Lawrence Senior has some health issues today, Lordship. That's the reason. Otherwise, he would have been here, Lordship.
Mr. Ganguly, yes. Too long.
My Lord, next week, my Lord, after Wednesday, any date.
You argued otherwise. This matter is a fixed item on
Thursday, my Lord. Next Thursday.
No, that's November, right? Next Thursday, court will be available. Next, this is on 20th November as a fixed item.
20.
It is understood the next date no further adjournment shall be sought. Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 23. Your Lordship, conducting counsel is Mrs. Angie Shilla and she is on sanction leave.
You have objection?
No objection, Your Lordship.
Yes, as prayed for. This is matter after
2 weeks, Your Lordship.
2 weeks.
No objection, Your Lordship.
You are appearing for correspondence.
Points 5 and 6.
Yes. Yes.
Obliged, Your Lordship. Obliged, Your Lordship.
Your Lordship, I beg to mention item 21, Your Lordship. If we can kindly have this matter after 2 weeks, Your Lordship.
Why?
Oh.
You ready to matter? You ready?
I'm ready.
2 weeks as requested, okay. And yes.
Hello.
After 2 weeks, yes.
Much obliged. Your Lordship, I beg to mention item number 20, Your Lordship. Your Lordship, I pray that the matter may come after 2 weeks. The conducting counsel is on today. For today, the conducting counsel is on sanction leave, Your Lordship.
Who today? Sona?
Mr. A.G. Moman, Your Lordship. I'm appearing on behalf of respondent number 4, Your Lordship.
2 weeks as prayed, yes. Yes.
May please, Your Lordship. Your Lordship, I beg to mention item number 25 on behalf of Mr. S.N. for MTDC, Your Lordship. Your Lordship, we were informed in the morning that the conducting counsel for the petitioner is not available today, so he had requested us, Your Lordship.
Where is he gone?
Mr. P.K. Mura, I don't have.
Where is he gone? Is available meaning? He didn't come to court.
Maybe, Your Lordship.
No, this matter after 1 week, yes. For 2 weeks. On the request of the counsel for the respondent number?
2 and 3, Your Lordship.
2 and 3, yes. Yes.
Obliged, Lordship.
Yeah, please, Lordship. I beg to mention item number 18, Lordship.
18? 18. It's already mentioned, correct? No.
No objection, Lordship.
Why?
Mr. Ashishek has some personal difficulty, Lordship.
Yes. Okay, after 2 weeks, yes. As paid by counsel for respondent number?
Respondent number 4 and 5, Lordship.
4 and 5, okay. Yes.
Obliged. Lordship, I beg to mention item number 22, Lordship.
Number?
Item number 22.
This is a language, big joke, yes. After 2 weeks, yes.
Highly obliged.
That's it. Firstly.
I beg to mention item number 19.
Sarita?
No, Your Lordship.
Oh, no, so sorry. What's the matter about?
Lordship, here, Lordship, my appeal was rejected by the
Your?
DGR. My appeal, I preferred an appeal.
Discharged.
No, Lordship. Because, Lordship, by order dated 23/3/2018, I was sentenced to suffer 3 years rigorous imprisonment by the respondent. So I preferred an appeal before the Directorate General of Assam Rifle, but my appeal was rejected on the ground that I have filed the appeal not within the limitation period. So that is the case, Lordship.
So why are you dealing with the matter?
Actually, Lordship, in this case, the arguing counsel is Mr. P.K. Roy, Lordship.
Mr.?
Mr. P.K. Roy. P.K. Roy Chaudhary.
Who's P.K. Roy Chaudhary?
From Guwahati, Lordship. So he's indisposed, so he could not come, Lordship.
But there is some technical difficulty, my lord, because they have come against the court-martial proceedings of some Rifles, my lord. Normally, these are registered as WP criminal, my lord. Because he has been sentenced to 3 years imprisonment.
He's undergoing it now. Where are you now? You're undergoing the imprisonment?
No, Your Lordship. I think he has, Lordship. Actually, I do not have instruction. There is the arguing counsel, Mr. P.K. Roy Chaudhary.
I know, fine. Is it interim order then? No.
No. My lord, so find this is page 19, my lord. This is the FIR. So here, what happened, my lord? He shot at his fellow soldier, my lord.
And injured him.
The service rifles. And injured him in the knee and neck, my lord. Though he survived, my lord, the victim. So attempt to murder was the charge against him, my lord. Page 19 was the FIR by police, my lord. And page 27, then the case was claimed by this court-martial, my lord. Page 26 is the order passed by CJM Kohima, Nagaland, transferring the case to Assam Rifles Court. And page 27 is the order passed by the Assam Rifles Court, my lord. Page 27. To suffer 3 years rigorous imprisonment, to be undergone in civil custody, to be dismissed from service.
So what happened? Where is situated now? What is the current position?
Lordship, now he's not in custody, Lordship. He's not in. He has already
been dismissed.
Served the sentence.
So he faced 3 years also.
Yes.
When was this passed? The order was passed on?
2014.
What's the date?
2015.
March.
The dates are indicated here.
Is the page 27, my lord? The last sentence, my lord, at the bottom.
Oh yes. 18th. You only served. So what's the purpose of what are you challenging now?
Here, Lordship.
Challenging a dismissal?
No, Lordship. So against this order, I've preferred an appeal before the Director General of Assam Rifle, but they have rejected my appeal on the ground of delay, Lordship. So this is the only small issue, Lordship.
Is there provision in law to condone a delay in such matters?
There is not.
When this appeal under the Assam Rifles Act.
But lots of kindness is the impugn order, page 29.
Does he have the discretion, the DG? Page 20?
Page 29, my lord.
Annexure 5 to page
Para 4, my lord, it says.
Yes.
Whereas the instant petition has been preferred under section so and so, Assam Rifles Act, read with rule so and so, the same although provides for the right of an individual to prefer post-confirmation petition, however, it has to be read with rule 179 of Assam Rifle Rule, which states that a petition after confirmation shall be submitted within 3 months of the date on which the sentence was promulgated. Whereas the said provision makes it clear that it is mandatory provision which requires the individual to prefer the post-confirmation petition within 3 months from the date of promulgation. In the instant case, the sentence was promulgated on 14 September 2018. In view of the above said fact, the period of limitation expired on 14 December itself. The petitioner has handed over a copy of the complete GRC proceedings of 14 September 2018. In spite of that, the petitioner has failed to submit the petition on time. The instant post-confirmation petition dated 8th March 2021. So delayed by 3 years, my lord. And he is taking a plea of COVID, my lord. COVID started in 2020, my lord.
Pre-COVID problem.
Pre-COVID.
You asked for reinstatement.
Lordship, here, Lordship,
You're not contacting counsel.
Yes.
His case.
How can he be reinstated anyway? If the consultancy would have been closed, anyway, Mr. BDEP on behalf of
P.K. Roy Chaudhary
submits place that the matter be adjourned due to unavailability, due to as the said counsel is indisposed. Just after 2 weeks. Nothing on the case.
Yes, sir.
May I please, Your Lordship? Your Lordship, I'd like to mention item 24, Your Lordship.
We're still on mention.
Yes. Your Lordship, as the counsel of the petitioner, Mr. P.K. Bora, he just contacted us saying that he's out of station, Your Lordship.
So you mentioned his behalf.
Yes, sir, he had requested me to inform the court.
That
Your
won't do.
Lordship.
Anyway, in the interest of just 2 weeks, yes.
Hello.
24.
Supplementary list, item number 1.
On the main list here. Huh? Motion we should also call from the main list for supplement. Yes. Yes, who's the petitioner?
My lord, the main counsel, actual counsel is from outside. Mr. George Thomas, who is supposed to be on the main.
Your
Yes.
Lordship,
Don't see any George Thomas.
I'm appearing for the respondent. In fact, this is an application under section 11 for the arbitration and conciliation.
So give the name.
Bhagiratha.
No, give the name of which arbitrator you want.
No, Your Lordship, there is a substantial issue involved in this petition because
Yes, under section 11, what,
res
11?
judicata
Huh?
are applicable in this case
What
for
is
the
judicata?
region.
Why?
For the region that a duly arbitral tribunal was constituted. It held the proceedings in respect of the same claim, which are the subject matter of this petition, and published an award.
It passed an award.
Then that award was set aside by district judge under section 34.
On what ground?
On the ground that there were many grounds, but the ground on which it was primarily set aside was that we have raised the question of jurisdiction of the arbitral tribunal under section 16.
You raised it.
Under section 16 before the arbitrator. Arbitrator has passed an order that this, after hearing, passed an order that this issue will be decided at the time of final hearing, final award when it is passed. When the final award came, there was no decision
on jurisdiction
on section 16 petitions.
Jurisdiction.
Yes, respondent that petitioner hearing entered appearance before the district judge. They said that in any event the award is not going to be sustained and it may be set aside, and that accordingly after hearing me,
What happened after that?
after that, Your Honor, they have come here again for section 11. My contention is this, that this petition is barred by the principle of res judicata. We cannot, supposing a person loses the case.
No, but if effectively there's been no award which can be implemented in view of the
award was there.
Whatever. So are you happy with the award?
Who? I was not happy. And he was also not happy.
Then?
He also filed a petition under section 34. I have also filed a petition under section 34. Petitions were heard and the award was set aside. Now, after setting aside the award, it raises a substantial question that whether again there can be a second round of litigations on the same claims which are already decided.
So you feel it should be limited in its jurisdiction?
Yes.
Where the petitioner?
My lord, it's some difficulties there. If I may pray,
Will-
next week, my lord, I'll inform the council and get in touch with you, my lord.
Your Lordship, we will accept the notice and the question of maintainability be left open.
appears for the arguing counsel. Sorry, Mr. S. N. Gupta, who is present on behalf of the petitioner, submits that due to some technical issues, the arguing counsel could not join. So, however, he prays that notice may be issued. Stopped. Seen the petition, is issue notice. Mr. V.K. General Senior Counsel is present on behalf of the sole respondent. How many respondents? One. Sole respondent and accepts notice. And Ms. Bijora accepts notice. With Bisya, who's accept notice. This is matter after?
I raised the question of maintainability. That's
This is the matter after so and so. Mr. V.K. Jindal is noted that Mr. V.K. Jindal has raised a question of maintainability of the incident arbitration petition. What listen? So, this is a matter for admission hearing on so and so. Take a date. After 2 weeks, better.
Lordship, the question of maintainability is left.
Admission hearing, we will have an admission hearing. Let the other side come first. We will have the hearing be effective.
But here, my lord, pursuant to an advertisement, my lord, the petitioner applied for the post, my lord. Page 17 is the advertisement, my lord.
Post of?
Teacher, my lord.
Unending teachers, yes.
This was on 24th July 2020. It only says, my lord, applications are hereby invited for the bona fide residents of so and so, having requisite qualification as per NCTE norms. So what was prescribed was only NCTE norms, my lord. And NCTE norms at that point of time, your lordship will kindly see the next page, my lord.
This is so. This is dated 2020.
2020, my lord.
Yes.
My lord, next page, your lordship will see what were the NCTE norms, my lord. Page 18. For appointment is so and so. HSLC passed with so and so, and diploma in elementary education, DLED. So I fulfilled this requirement, my lord. I was DLED at that point of time. And I was a candidate, I applied for it, my lord, and I was appointed. The appointment order, your lordship will find at page 21.
Page?
21.
So you have HSC pass 5% and so, diploma. You have that. You have all the qualifications.
My lord.
So where's the appointment order?
Upon page 21, my lord.
Yeah.
To effect the operation of resolution number 2 of the school managing of so and so, dated so and so, the undersigned pleased to appoint Sri Karimul so and so, BA, DLED and B.Ed, pursuing temporarily the post of assistant teacher of so and so, subjected on the condition that the incumbent will have passed the MTET examination within 3 attempts, and in the event of failure, the service of the incumbent shall stand terminated without any prior notice. Well, what happened, my lord, at that point of time in 2020? Because this is from Dadangri, the MTET examination was scheduled, but it was cancelled because of certain reasons, my lord. There were many litigations on that. So at that point of time, no MTET candidate was available. So a special provision was made that I will pass within 3 attempts, my lord. This was again approved by the government, my lord. Well, we'll see page 26, my lord.
Yeah.
This is from Subdivisional School Education Officer, as recommended by the SMC of so and so, by the resolution number 2, meeting number so and so, and in exercise of powers conferred by the Director of School Education and Literacy Meghalaya Shillong, by his letter number so and so, Sri Karimul, the petitioner, DLED, part is hereby.
22, son, yes.
My lord, appointed as assistant teacher in so and so, so and so. The next page, your lordship will see, because in the original appointment order, the 3 years. 3 attempts was not mentioned, my lord. A corrigendum was issued, my lord, page 27, my lord, by the Subdivisional School Education Officer, yes, saying that incumbent to clear MTET examination within 3 attempts for regularization of service. So, my lord, since then I am serving, my lord. I have taken 2 attempts, my lord, in MTET, but third attempt is yet, the exam is yet to be conducted. Now what has happened, my lord, in the meantime?
What you failed?
2 attempts I failed, my lord. My lord, that is the only question, my lord. The third, as per my condition of appointment, I am entitled to 3 attempts, my lord.
3 attempts or 3 years? Where the appointment?
3 attempts, my lord. Page 27, my lord. Maximum 3 attempts.
Yes. So what happened after that?
Now, my lord, there were certain complaints, my lord. Page 29, your lordship will see there was an inquiry conducted, my lord.
Why inquiry?
Inquiry because there was some report that I'm unqualified person. I'm not
behest.
My lord, your
The
lordship.
state responsibility has itself.
Page 28, my lord. It says, my lord, with reference to the site, I am to inform here with a copy of the Ceylon Times News.
Okay.
So on the basis of that, the inquiry was conducted.
In the inquiry?
On the finding, page 32, your lordship will see. Para 4, my lord. That as per the claim of the SMC, there was no MTET qualified teacher in the locality at the time of appointment of teachers, as the MTET examination was conducted in Meghalaya in 2019 for the first time, and MTET examination 2019 of Dadangiri subdivision had also been quashed and reconducted only in 15 December 2020. Then para 6, my lord, that the then subdivisional school education officer Dadangiri issued appointment to Sri so and so, dated Dadangiri so and so, as per MC resolution number 2, and the letter issued by the director of school education literacy Meghalaya Shillong White number so and so. My lord, para 10, my lord, on the next page, my lord, page 33.
Have you been terminated now? You're terminated.
My lord, now there is a direction by the director of school, my lord, to re-advertise the post, my lord. And
When is the next MTET exam?
It has not been notified, my lord.
Okay.
My lord, para 10, your lordship will see that the teacher is in continuous service in so and so till date, and the government of Meghalaya Department of Education is pleased to release his salary with effect from July to April 23. However, the office of the undersigned has temporarily kept pending of the release of his salary for the month of May 2023 based on the complaint lodged against the teacher. Now, my lord, there is a second inquiry, my lord, at page 35. My lord.
Page
35, the operative part, page 36, my lord.
Yeah.
The last paragraph. In view of the above facts and circumstances, Sri so and so may be allowed to continue till he has completed the 3 attempts as per agreement signed between him and the SMC of the concerned school till he gets another chance to clear MTET to meet the ends of justice. But in spite of that, my lord, now what has happened, my lord? Page 37, my lord. This is the first impugned order, my lord.
Okay. Yes, this is on 19 July. Okay. Next.
This is a writing to re-advertise the post, my lord. My lord, my case is that as per terms of appointment, my lord, I should be allowed to continue to the 3rd attempt of MTET. If I don't qualify, I naturally have to go, my lord. What I am entitled, and moreover, I am entitled to my salary also, my lord. Since May, they have not paid salary.
Yes, Mr. Shulai.
May it please your lordship. Lordship, the admitted fact is that at the time of the appointment, your lordship, the petitioner doesn't have the
right, but given 3 chances, if you have availed 3 chances,
kindly come to page 38, your lordship.
38.
Yes, your lordship. RTE, your lordship, RTE has been made applicable, your lordship, on 1st July 2020, and the advertisement, your lordship, in this case, your lordship.
No, 38. What do you have to 38?
Lordship, that means to become a teacher, your lordship, in a school, a person has to obtain the required qualification, that is the teacher eligibility test.
But then in spite of existence notification, if you have given him selection, there's no MTET officer.
That is why it has come.
At your own level, you have controlled
no,
the
your lordship.
requirement.
That is why, your lordship, this has been done by the subdivisional office, your lordship. When this matter was brought in the newspaper, your lordship, that's why the director asked the lower authority to re-advertise the post, Your Lordship. Lordship, because Section 23 of the RTE Act 2009,
but you look at
it is mandatory.
You look at a case-to-case basis now. If he was not given appointment at the outset, then there's no quarrel. But if you there's some civil consequences on the petitioner by your action. Now, do you think you can shirk that unless by
Lordship, can you see, Lordship?
Have you taken action against the officer appointed him?
Even issuing a notice to him also, issuing a notice to him also. No, Your Lordship, that I don't have instruction. Even issuing a notice before issuing this impute order, Your Lordship.
Yes. You have an interim prayer.
My Lord. My Lord, not to disturb his service, my Lord.
Heard Mr. Dr. M. Mozikala say, counsel assisted by M. Nokul. The grievance as made out in the petition is that the petitioner had been appointed when?
12/8/2020.
Possess NCTE norms was appointed
on 12/8/2020, my Lord.
On 12/8/2020. However, with the stipulation that he obtained the MTET qualification within 3 attempts. Stop. The petitioner is aggrieved with the fact that though he is yet to make the 3rd attempt, the respondents have directed for re-advertisement of the posts on the ground that the petitioner initially did not possess the MTET qualification. Stop. Let's say counsel prays that in the interim, in view of the existing situation, the services of the petitioner be not disturbed. Stop. Next paragraph. Mr. N.D. Shulai, EAG with so-and-so appearing for the respondents.
1 to 4, Your Lordship.
1 to 4 submits that the requirement is mandatory and the appointment of the petitioner, the said requirement is unsustainable, and as such the respondents are directed for readvertisement. He further submits that on the unilateral action of the subdivisional education officer in approving the said appointment, you assure him show cause.
No, Your Lordship, that I don't have the instruction, Your Lordship.
He doesn't have instructions as to what problem sentence.
For this, Mr. The unilateral action of SDU in approving the said appointment, he has no instruction.
Is being looked into by the state respondents. Stop. Next paragraph. Having heard the counsels and considering the after consideration of these submissions, after having heard the counsel and considering the materials as present on record, in view of the fact that the petitioner has clearly been afforded 3 opportunities to qualify the MTET, which yet to be availed of, a prima facie case for interim protection has been made out. Stop accordingly until the next date, the service of petition will not be disturbed. And further, if he is serving, whatever salaries which are pending should be released.
My Lord, respond number 5, I'll take steps.
Stop. Petitioner takes step for issue notice to respond number 5 within 3 days. Just after 2 weeks for instruction stroke affidavit.
Obliged.
Yes.
Main list, item number 1.
Take away the motion number 2. Yes.
My Lord, last time it was moved, there was a little requirement. Additional affidavit was supposed to file. We have filed the additional affidavit, correcting the.
What are you praying for here?
I'm praying for implementation of the employees' provident fund schemes.
For you, what you are?
I'm the daily laborer contractual employees of the PWD department, and that the
act was notice issued earlier or no? Yes, heard Mr. H.R. Nath, of the petitioner, who submits that as directed by this court, an additional effort has been filed, indicating the posts, the names and the posts The names,
office bearers,
the names and the
names of the office bearer of the
bearers
petitioners union.
of the petitioner association. Stop issue notice. Next for issue notice returnable in 3 weeks. Stop MSZE non-country is present except notice on behalf of
Respondents 1 to 5.
1 to 5. What about 6?
Respondent number 6.
Your name?
Z.H. Chaudhary. Under instruction.
Mr. So-and-so is present on behalf of number 6. Vice MSP Bharatkanji and except notice number 6. As such, notices, no further notice required on
The Chief Secretary, so which we need to bring in record. Kindly allows some time.
You file your affidavit. Yes, as such, notice is complete. No further notice. Respondents permitted to file affidavits in the meanwhile. Yes.
Obliged, Your Lordship.
Item number 2.
The main list. The main list number 2.
I think the writ petition doesn't survive, Lordship, anymore, because we have already taken steps to incorporate in the budget.
Correct.
The pension of the MDCs as well as other MDCs or other servants, retired government retired servants.
Yes.
As of now, there's nothing survived, but in the event we don't, they can always come back.
Lordship, we were not informed about all this because we have already filed our representation also.
We will not inform them because we are already having communication with them. We had a meeting and all these things with all the MDCs.
We were not being called.
You're sure? No instructions?
No, Your Lordship. We were not being called in any of the meetings by the district council.
See, since the last time was listed 3 months ago, she's come to court after 3 months also.
We have made a public statement also by the chief executive member.
Mr. Vijay Kantale's senior special counsel for the KHC submits that steps have been taken by the respondents to address the grievances of the petitioners and other similarly situated persons, and funds are being made available to.
Funds are being procured.
Are being procured to pay to afford them pension. Stop. MSP Khanonlang submits the careful instructions in this regard, and pays matter is after 2 weeks able to obtain the same. You obtain the same if it's a complex matter to further orders.
Highly obliged. Item number 3.
Please, Respondent have not yet filed affidavit.
Lordship, as per my instructions, the document had been sent to Shillong, but no communication as such has been made.
What document?
The affidavit, Your Lordship.
How is the court concerned about that? The court is concerned whether it's been filed or not.
Yes, Lordship, I pray that last opportunity may be given, Lordship. Whether
How many times you've taken? How many times have you done? Anyway, further 2 weeks time I've prayed under affidavit.
Item number 4.
Petitioners.
It's for 7-level petition today for hearing.
My lord.
It's for what today?
My lord, they have filed the application about the maintainability under Order 7 Rule 11.
Yes, where's that? Aye. Miss case. Mrs. Miss case petition.
That would be Miss Case 25.
Yes.
Okay.
You are going to argue?
Okay. Was he not present?
Malars?
Was he present when he filed election petition? The election petition?
Yes, Your Lordship.
Very much. He presented himself.
Yes, Lordship.
Before the stamp reporter.
Yes, Your Lordship.
That was recorded.
I'm not sure about the records, my God, because it is for the duty of the learned registrar and stamp reporter to present the report, my lords.
Let's see the stamp report. See, this court already passed an order on the 711 application on the same ground where they've said that the...
If I may take your lordships to just a few...
1 second. Stamp reporter. You find 17,423.
We have started the process on 13th, your lordship. On 13th, we have started the process of filing it.
Yeah. And then?
Lordship, I have mentioned in my reply, if my lordship may kindly see our reply.
Let's see a reply, yes.
Yes, your lordship.
That'll be important. Your allegations only that he was not present.
Two allegations I have, my lord.
That means violation 81(1)
I have,
it should be automatically dismissed under section 86 of the RP Act, correct?
Three submissions I have, my lord.
Your
very
first
short.
submission?
The first submission is a violation of 81(1), as your lordship, that he was not present.
So 86 will come into play.
The second submission is that this is a case unlike the others where there is a subsisting contract or some defect with the ballot box. This is a case of they are alleging corruption.
Practice.
And there is no specific affidavit as provided under section Rule 9A of the conduct rules for a specific affidavit setting forth the particulars of the corruption that has been alleged. And thirdly, my lord, since it is a case of alleged corruption, full particulars have to be pleaded as provided under the RPA, my lord. And full particulars have...
Regarding corrupt practice is different matter, but you come to technicality like 81(1). Now, if you can show that he was not present, he hadn't presented in the proper form as per the section 81 and as per the High Court rules.
I am aware of.
Then if we can satisfy that, then it goes out in 86 under 86 only.
Yes.
Corrupt practice, I think maybe we have to. That is a different.
If I may only take a few to page 4, my lord, of their reply. Of their reply.
Okay.
Page 4, lordship, paragraph 6. Paragraph C, my lord, I'm sorry.
Page 6.
Page 4, paragraph C, lordship.
Yes.
C. 4 lines from the bottom, my lord. It starts with further. Further, the allegations of violation of section 81(1) of the RPA 1951 are vehemently denied. It is submitted that the mandatory requirement of the said section is substantially complied with by the answering respondent. So there is an inherent admission that it has been substantially complied with. Now, how it has been substantially complied, Lordship will kindly see paragraph K at page 9. K, Lordship. Paragraph K at page number 9, Lordship.
Yes.
If I may read, my lord, it is submitted that the allegations regarding the non-compliance of provisions of 81(1) of the RPA are absolutely false and devoid of any merit. It is respectfully submitted that the election petitioner respondent herein has substantially complied with the mandatory provision in the true spirit of the law of the land. The election petitioner signed and swore the true copies of the petition along with all the mandatory affidavits, annexures and true photocopies in the physical presence of the authorized notary on 13th of April 2023 at her home, as she was not well on the day. In spite of all the regular and frequent load shedding, power cut and the massive traffic, the election petitioner rushed to the High Court after that. The election petitioner ran to the registry and reached the High Court registry just few minutes before 4 p.m. As per the rule of limitation to file the election petition prescribed in RPA 1951, the election petitioner still had ample time. The election petitioner and his advocates, taking care of the convenience of everyone, after substantial compliance of the mandatory provisions, decided to complete the remaining formalities of election petition on the next day. However, all of a sudden, in the late evening of 13th April 2023, it came to the knowledge of the advocates of the election petition on the next day, that is the 14th, was declared a holiday on account of the birth anniversary of Bharat Ratna and former Law Minister of India, Dr. B.R. Ambedkar, by way of a notification in the late evening. Thus, the registry was closed on 14th April and after that, on 15th April 2023 being Saturday, it was closed. On 16th April, the registry was closed on account of a Sunday. Therefore, the remaining formalities associated with filing were completed on 17th April 2023. Relevant check slip was issued by the registry, states that there is no defect. So, Lordship, in his own submission, he was present before the notary, not in this court, but at the house of the notary on 13th. He may or he may not have come on 13th to the court, but admittedly it could not have been
So,
filed.
okay, you just tell the court then, can this, on the materials, like which are before this court today, can it be discerned conclusively that he was not presented personally before the registry?
When the date of presentation, my lord, has to be constituted not as 13th but as 17th. Because admittedly he has filed the
So admittedly you say that by the materials on record, on 17 he was not nowhere to be found.
As per his own statement, my lord, that he came with the notary on 13th at her house. He came on 13 on the registry, it could not have been filed. 14, 15, 16 were holidays. 17 the advocate filed it. And he is saying it is a substantial compliance in the true spirit of the law of the land. It is his own admission, my lord, that on the date of presentation, which is 17th, because no presentation happened on 13th, my lord.
Okay, let them answer. Yes.
My lords, before coming to answer this question, my lords, they have filed this miscellaneous application under order 7 rule 11, my lords.
Yes.
I want to attract my lord's kind attention to the order 7 rule 11, my lords. What the order 7 rule 11 says, my lord. It's about the rejection of plaint, my lords. An election petition is technically a plaint, my lords. The plaint shall be rejected in the following cases. A, where it does not disclose a cause of action.
Yes.
As per their miscellaneous application, they are not alleging that.
Sorry, yeah. Yes.
My lords.
Yes.
The B, my lord, says that where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the courts, fails to do so. This is not their case, my lord. C, my lords, where the relief claimed is properly valued but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time frame to be fixed by the court, fails to do so.
Yes.
This is not their case, my lord. D, my lords, where the suit appears from the statement in the plaint to be barred by any law. In my lord, this is not their case. Where it is not filed in duplicate, there are explanations, my lords.
Yes.
Now, my lords, if we see further the rules of the High Court regarding filing the plaint. It is very important.
Are you going on a general provisions, or are you specifically
my lord.
are you addressing a specific question regarding election petition?
Question, my lord, as per basis.
No. Listen, the thing is that these petitions are under a special statute, correct?
Exactly.
Now, what are the requirements of section 81? Now, of 81 and 82, and what does 86 say? Right? You
Yes,
must
my
have
lord.
examined that. Now, that is one part. Now, the next part is that this High Court has adopted the rules of the chapter 8A, I think, of the Guwahati High Court rules,
Yes, my lord.
which
Guwahati High Court
provides how
state-
is a election petition be presented and before
Yes, my
whom. And it says that now election petition is presented before an authorized officer.
Yes, my
and whether that rule describes who's authorized officer and whether the election petition was presented before the authorized officer.
Yes, my
In
lord.
this case, in our High Court, stamp reporter.
Yes, my lords.
So in that regard, now we have to satisfy the court that yes, forget 711. 711 is a general provision. It's a general law applicable to rejection of plaints. Correct?
Yes, my lords.
So you cannot advance arguments on saying that 711 is not, there's no ground on 711.
They have filed this under that. That's why that's my only humble submission.
Throughout India has been filed a 711. Right? Read with 711 is a petition under section 86.
Yes, ma'am.
Under 86.
151 also.
Okay. So you have to satisfy this court that the requirements of section 81.
Yes, my lord.
And the requirement as given under the High Court rules have been met.
Yes,
and
my lord.
if that has been met, then your petition is not effective and good.
My lord.
That's all, yes.
My lord, the whole superstructure of the election petition, the
Yes.
way of filing it, my lords, It's a very detailed where the court has in so many times in so many judgments has specifically mentioned that it is an act in itself. My humble submission in respect of the application filed by them under Order 7, Rule 11. My God, they have filed it. This is their decision. Now it is for them to justify the filing of Order 7, Rule 11 along with the High Court. They have alleged that I have violated that under that. That's why my plaint need to be dismissed, my lord. Now, here, by giving into the plain reading of the Order 7, Rule 11, my lords, there is no case, there is no ingredient as alleged in their application, my lord. This is my basic argument, my lord. Now, coming to the second part of that, as far as the Guwahati High Court's rule about presenting it, again, they have failed miserably to present that. Now, coming to the basic thing, as far as their things are concerned, you kindly see, my lords, the reply of my it is, my lord, K, as they have suggested. I will start with that only. My lords, it is respectfully submitted that the election petitioner, respondent herein, substantially complied with the mandatory provision in the true spirit of the law of the land. Now, what the law of land says, that's very important. Law of the land is not hyper-technical about filing the election petition, my lords. It is not something which is construed in a very hyper-technical manner, because filing of election petition is a process, my lord. It's a flow concept. It's not a stock concept where at particular point of time we decide something. It's a start with the presenting the facts before the lawyer, then converting it into a plaint, thereafter the proper filing affidavit and everything. In that, the court is very clear, the statute is also very clear that it is either by him or by the court. I will satisfy my lord with the relevant judgment on this part also, my lord. But first I want to come on the date. As alleged my friend that it is an admit. It is also very important, my lord, that in their miscellaneous application they have not added any annexure, any concrete evidence, nothing. They are relying on my submissions and saying that these are not substantive, my lord. First saying that speculation, that elephant is without tail. Then saying that elephant without tail is not elephant. That is something against the interest of justice, my lord. Now, coming to that. The election petitioner signed and swore 2 copies of the petition, along with all the mandatory affidavits, annexures, and 2 photocopies, in the physical presence of the authorized notary on 13th April 2023 at her home. There is no restriction, there is no law which bars that affidavit cannot be sworn at the place. There is nothing which directs that the affidavit need to be sworn only in the court premises, my lord. The reason is that she was not well on that day. In spite all that, because we know, my lords, that in Shillong there is a frequent power cuts, there are traffic issues and all that. So the election petitioner, along with the advocate, presented before the registry on the same day, my lords. They rushed to the registry after finishing all these legal technical requirements, and they presented before 4 o'clock. There is nothing on record which says that he was not present at the time of presenting the election petition before the registry. He was very much there.
On 13th?
On 13th, my lord.
Okay, 13/4/23.
Yes, my
present
lord.
in registry.
Before the 4th. And you know, lordship, in the practical world, whenever there is a less time, we normally don't force the registry to overwork after 4 o'clock, because normally that's the timing. So the issue here is that he was very much available physically with his advocate. So as far as the compliance of the relevant section is concerned, it is already there, my lords. Now the only issue is remaining about the completing the remaining formalities of filing the. And all in the practical wisdom, my lords, we never force the learned registrar or the officers to complete the thing by unnecessarily extending their time of work.
Okay.
So I was very much present, my lords, on that day. So as far as the requirement, the mandatory requirement, if we accept that, if we assume that it is a mandatory requirement at all. So by here it is defined by the courts in different manner, my lords. But even if I assume that my physical presence is mandatory, I was very much there. I presented it before the registry.
On 13th.
On 13th, my lords.
All right.
Now, to complete the remaining formalities, we have decided to complete it on next day.
Who decided?
It's the election petitioner and the advocate, my lords.
Okay.
Now, on the next date, in the late evening of 13th April 2023, it came to the knowledge of the advocates of the election petitioner that the next day, on 14th April 2023, was declared a holiday on account of birth anniversary of Bharat Ratna former law minister Dr. B.R. Ambedkar, the Baba Sahib's Ambedkar. This was decided and declared the holiday by way of notification in the late evening. So the lawyer, the advocate of the election petitioner, received this information. Therefore, the practical impact of this is that the next day the court was closed, the registry was closed on 14th of April.
Okay.
On 15th of April 2003, being a Saturday, it was closed.
So okay, come to 17th. Did he come on 17th?
No, my lords.
Didn't come. When, because the petition from the date, it was registered by the, stamp reporter's seal is on 17th. Okay. Right.
Right, my lords?
Yes.
Now, the remaining formalities associated with the filing was completed on 17th of April. So
Yes.
here, my lords, my humble submission is that being a flow concept of filing that is already started. At the start of that, he was very much there. But at the time of completing the formalities,
Yes.
he was not there. I'm not concealing any fact, my lord. But at the same time, I am also humbly requesting to my lord that it should not be construed in a hyper-technical manner.
Yes.
Now, the relevant check slip issued by the registry of the Honorable High Court states that there was no defect in the filing of the election petition. It is submitted that the registry of Honorable High Court has duly accepted the election petition.
Yes.
If we assume that there was some defect, so it is the duty of the learned registrar and the concerned court staff to point out that.
Correct. Yes.
Because I am here for something which is detrimental to the interest of the fair norms of democratic rights.
See, what's your name, sorry?
I'm Devendra Sharma, my lords.
Mr. Sharma, you understand that if you're so concerned about, the democratic rights, you understand that filing election petitions is a very serious business.
My lords.
And if in all seriousness, if you're so concerned with democratic rights, that means you should be alive to the fact that all compliances as given by the statute, since it is, hyper-technical and technical, have to be complied with.
Yes, my lords.
But if you're casual, if you say that fine, like it is a flow concept, the flow concept that I came on 13th and it was filed on 17th. So you're asking the court to to increase the boundaries of what is permitted by law, to say that now in election petitions there's a flow concept now. It's like a surgeon starts the operation, he leaves it, and the patient dies. Look, the flow concept is like I did the operation.
My lord,
I didn't do it.
I'll definitely convince my lords on this aspect, my lords.
Yes, you have said flow concept, right?
Yes.
Okay,
I'm saying,
and now you admit that on 17th he was nowhere present.
No, my lords, he was not there.
On the report, a stamp reporter, which just says, he just notes this file, right? Yes.
I'm not aware about the report of the stamp reporter, my lords. It is not at my disposal. But what my submission is that, my lords, that on the 17th, while completing the remaining formalities of that, there was no question. There was no question raised by either the learned registrar or the officials appointed by learned registrar demanding the physical presence of the election petitioners. And that's why there is no harm and there is no legal bar in assuming that they were satisfied with the presence of the election petitioner on the 13th, on the day when it was presented. So it was presented and it was completed, my lords. And again, I am saying that it is not the error or error by any part because of the all of a sudden announcement of the holidays and thereafter the Saturday and Sunday, my lords. So my submission limited to this aspect, my lords, that when the learned registrar is satisfied, the registry is satisfied, they have never raised any question on that part. So creating a issue which is actually a non-issue on hyper-technical basis, that is not valid, my lords. I'm coming to the next part, my lord. Hence it is submitted that the allegation of respondent number 1 are baseless and devoid of merit. Moreover, the provisions are merely directory in nature and effect, which was duly complied by election petitioner, my lord, and is advocate to the utmost satisfaction of the registry of the Honorable High Court. The respondent number 1, my lords, is unnecessarily raising this issue, challenging the wisdom of the learned registrar. Now, if we see the rules of the High Court, my lords, in the chapter 8A, whether the rules direct, if the rules are not directing, if the election petitioner was present at the time of presenting the election,
who is the authorized officer before whom election petition is presented? Correct.
My lords.
Now I've not seen anywhere in your petition or in your reply that it was presented before the duly authorized officer, which is a stamp reporter.
My lords.
That I've not seen anywhere. That we went before the stamp reporter, it was going to be 4 o'clock. There's nowhere, right?
Lord, my lord.
Yes.
My lords, if I may say so, my lords.
Yes.
That the High Court, what is High Court, my lord? High Court is not only consist of the judges, but the registry and the staff appointed by the learned registrar to take care of the procedural requirement also. That constitute High Court, my lords.
Yes.
Each and every officer, my lord, is part and parcel of the institution of High Court, my lords.
Of course.
I'm not on the, because I'm not a practicing advocate here, my lords. So I'm not aware about the technicalities of the registry here. But I safely assume, my lords, that all over India, the registrar is definitely not available to accept each and every petition, my lord. It is presented, it is accepted, therefore after it was verified as per the laid down rules by the concerned staff, and if there is any anomaly, any defect, any requirement further, they inform the advocate or the petitioner. Thereafter, after getting the information and within the due time, it must be rectified properly to the most satisfaction of the registry, what the Order 7, Rule 11 also specifically declares.
Yes.
Now, if there is any such process adopted by the learned registrar or the associated staff,
you're not aware about that?
No, yes, not at all. There is nothing on record. There is nothing in their application also. So it is purely speculation, my lord. It is a speculation, and on the basis of that speculation, they have created a argument that he was not there, but he was very much there. He was very much there. Now coming to the...
Does your petition remember before whom they had come after they rushed to the High Court?
Yes, if my lords may direct, I can inform the election petitioner to appear before my lords. I have no
because there's a
hesitation in
question,
that.
you see, if we are to decide this issue, then it'll have to be framed as a preliminary issue.
Definitely, my lords.
Before we take up other issues. Because if it comes to later ascertaining that now you had come on 13th or you were present 17th or whether presented by the stamp reporter to the satisfaction, that is important to see.
My lord, that's why I am saying, my lord, this issue specifically and the relevant issues require detailed examination. At the threshold, my lord, it should not be summarily rejected in this manner. The crux here is that it requires a detailed examination. And how is it possible, my lord, under the Order 7, Rule 11, read with the relevant rules of fee, decide such an important critical issue?
Yes.
This requires a detailed examination. That's my submission, my lord. Rejecting an election petition, my lord, it should not be in such manner, my lords. Where specifically in this application they failed to disclose.
Now, one thing, Mr. Sharma, are you shifting the onus of the deficiency on the registry?
No, my lord, certainly not. I have submitted in my
What have you said in your objection? Are you placing the onus on that if it is not my lookout? Like you said, just not my lookout, the registry, what it does, or who's a person authorized, and so that I've thrown in my election petition, and if they had objections, they should have raised it then. They have not raised it now. That have come by way of 711 application. My application will be thrown out. Now, what is your responsibility, as an election petitioner? If the election is a very serious matter, like to see that everything is complied with.
My lords, may kindly see the page number 11, my lords. Page number 11 of my reply.
Okay.
In that, my lords, I have said that the provisions are merely discretionary in nature and effect, which was duly complied by the election commission.
Where are you reading from?
It's page number 11, my lords.
Right.
It is the first paragraph. It is the continuation of paragraph K, my lords.
Okay.
I'm not shifting, my lord. Not even my dreams, my lord.
Okay.
Yeah. Moreover, the provisions are merely discretionary in nature and effect, which was duly complied by the election petitioner and his advocates to the utmost satisfaction of the registry of Honorable High Court. The respondent number 1 unnecessarily raised this issue, challenging the wisdom of the learned registrar. They are challenging, my lords. I am not challenging.
Okay.
I am not challenging. Certainly not. Not even in my dreams, my lord. Being a practitioner of law since last 2 decades, I definitely not raise. Okay. The issue here is, my lord, if my lords may say see the next paragraph on the same. I'm trying to answer my lord's question that the respondent number 1, applicant herein raises frivolous issues and create unreasonable doubts against the learned registrar.
Yes.
Which may be manipulated as a direction of duty of the learned registrar.
Okay.
Assuming that it was the duty of the learned registrar, even if we assume, my lord, that it is, the High Court or its subordinate officers to inform the election petition has to be presented personally every time by the election petition as per the applicable rules, though there is no such rules, my lord. I'm just assuming there is no such rules, my lord. But even if I assume my learned friend's argument that I have to present at the each and every stage of presenting the election petition, my lord, even in that case, my lord, there is no reason to doubt the sincerity of the office of the learned registrar while accepting this thing and not raising the question about any defect in the election petition, because there was no defect at all, man. This is their speculation, my lord. Just like as I submitted before my lords, that first assuming that elephant is without tail, and then saying that the elephant without tail is not elephant. There is no reason, there is no ground behind that, my lord. Coming to the next one, my lord. The applicable rules after citing the rules or informing the advocate of the election petition. However, in this matter, no one informed the petitioner or his advocate that the election petition has to be personally presented again to stamp reporter or the election petitioner present in the registry on the previous working day. No one raised that requirement because there was no requirement at all.
Yes.
If there is no requirement, there is no legal direction as per the statute or by the rules, then there is no reason to raise that, my lord. Just because, my lord, few decades back someone raised this and the honorable courts has decided something in favor, that cannot be continued in that manner. Specifically, my lords, in last 2 decades, if I may say so, my lords, after the judgment of the PUCL, after the resurgent India, the overall approach, the philosophy of the election petition has been changed. It is a dramatic changes in, my lords, because of the malpractices used in the election practices. That's why the courts are taking active role to curb the electoral malpractices and the corruptions. And here my issue is to raise all those issues, to address all those issues, which is actually now the grundnorm of the law, which is carefully nurtured, nourished, strengthened by the Honorable Supreme Court.
To bring you back to full circle in the arguments.
My lord,
the thing is that see your flow concept argument.
Yes, my lord.
See, that's what you're advocating. The flow concept that on 13 you had come, 17 not there.
Yes, my lord.
If you taken to as to be perceived.
I'll come to that also, my lord.
What has a lot of doubt. That's all.
I'll come to that, my lords. Again, my they are relying on Sri Ramma Reddy versus another versus returning officer, my lord. This case is not relevant, my lord. They have cited only one judgment, my lord. And in this judgment, if we go into the details of that judgment, my lords, here the registry raised the question about the absence of election petitioner, my lord. May I ask, my lords, with your permission, that my learned friend has some information that the learned registrar had raised this question, which is in their knowledge but not in my knowledge. So, relying on a judgment which is not applicable in my case, my lord.
But the G. Srima Reddy says that, what are the mandatory provisions?
My lord.
The only thing. Yes.
My lord.
Notwithstanding anything else.
No. Yes, my lord. That this, yes. Just 2-3 lines before the this bold lines, no one raised the requirement or no one prepared a note annexing it with the election petition that the petition was personally presented by the election petition himself. This aspect is clearly demonstrated in G.V. Sri Ramma Reddy versus returning officer and others, wherein an objection was raised by the registry that there was no proper presentation of the election petition in terms of section 81(1) of the Representation of People Act. This is certainly not in my case. There is no such report of the registry. It is explicitly clear that an objection has to be placed by the registry in view of any non-compliance at the time of filing the election petition. So, in view of the objection raised by the registry in the above matter, it is explicitly evident that it is the duty of the registrar. This is not I am saying, my lord. This is the judgment which says that.
Yes.
It is the duty of the registry or the stamp reporters to communicate to the election petitioner or his counsel that the personal appearance of the election petitioner was necessary every time during the process of filing the election petition.
Yes.
It is expected that no such requirement was, next page, my lord, page number 12, also communicated to the other election petitioners. It is humbly submitted that the filing of the petition is a flow concept, my lord. I'm coming to address my lord's question, which requires
any authority in this flow concept.
My lord, there is no Indian authority.
This is the first, propounding this theory for the first time.
I'm not propounding, my lord. I'm not propounding, my lord. It is there, not in the form which I am trying to present it before, my lords.
It's a very interesting concept.
Yes, my lords.
Beat the
my lords,
flow concept.
The element of law depends on such concepts, my lord. The basic, what is law, my lords? If I say in particular context of election petition, my lords.
Yes.
Election conducted by the election commissioner as per the Representation of People Act. People cast their vote after the campaign. The campaign which need to be conducted as per the statutory requirement. There are so many judgments on that, and thereafter the casting of the vote. Now, after the judgment of PUCL, the resurgent India, there is a clear explicit structuring of the whole issue in what manner election should be conducted, which earlier it was not. Even the role of election commission after the TN session, it was remarkably changed.
We are digressing. Only that I brought you back to what is the flow concept.
Exactly, my lord.
Will it be acceptable? Will it be an acceptable kind of proposition?
Yes, my lord.
For this court to consider.
Yes, my lords. That's my humble submission, my lord, that filing a petition, it is not a stock concept. Reason being, it is not something which is delivered at one point, my lord. Even if we say that the presenting of the election petition before the office, in the office of the registrar, it inherently, necessarily includes series of actions, my lord. I have presented, they have seen that, accepted that. Thereafter, they need time to check that. They may check it on the same date, they may check it on the next date also. So it requires that, my lords. So the point of time and a different point of times doing the same thing. That is the difference between flow. A dam is a stock, my lord, and river is a flow, my lords. A river is a river, which is the basic requirement of the dam, my lords. In the legal, in the jurisprudence sense, my lords, that what the RPA advises, my lord, and what executed by the registry, that is also in the same manner, my lord. And in every sense, my lord, the presence of means the applicant, election petitioner here, at the time of presenting the election petition, he was very much there. And even at the time of accepting that, there was no question raised by the learned registrar or the subordinate staff that his presence need to be. There is nothing which is received by me. I don't know what is actually on the record. But I am 100% confident about that. They have not raised any annexure. They have not raised any question about that.
Okay.
Now,
anything else?
Yes, my lords. There are series of, my lords. I need another 30-35 minutes, my lord.
30-35 minutes?
Yes, my lords. It can be part here, my lord. I can come again, my lords.
We can do one thing. What do you have to say? You give your bullet points, please cite it. I don't want written arguments also.
See, on the flow concept, so I'll just...
What about the overflow concept?
My lord, whenever there is an overflow, my lord,
Yes.
it causes distractions only.
Yes.
It causes distraction only. I'm not agree again.
There's also the issue of Rule 9A, my lord, because this is an allegation of
You
corruption.
would argue 9A. Okay, refix it again.
My lords.
Yes.
My lord, if it is...
That's substantially interesting concept we are propounding.
My
yes.
lords. I
It's the
convinced
first time-
my lord, my
I think
lords.
the first time this court has heard about, the filing of a petition, where it's a flow concept, which starts from the thinking of filing the petition to the presentation and the
My lords.
representation.
My lords. My lords, it's a evolving law, my lords. Know that.
Of course.
It's a evolving law, my lords.
Everybody has to adapt to evolution.
Yes, my lords.
Yes.
My lord, if
So
it is
this is
after
my-
20 or 22, my lords, then it will be bit convenient for me.
This is matter also and so for further hearing. Yes.
On 22nd, my lord?
You take the date.
My lords. Much obliged.
Item number 5.
May I please, Your Lordship?
Where's the affidavit?
Yes.
File.
Yes, I have already filed my lord.
Yes.
Yes, I've received your lordships. Your lordships, in the affidavit, they've stated that now what is pending, it's before the Under Secretary Finance Department for approval of the
I am coming to the
initial pay statement.
annex of 2, my lord.
Okay, affidavit.
Page number 11.
Yes.
Shall I read out, my lord?
Yes.
Pension in respect of Sri Ram, retired peon office of the 41 Meghalaya BN NCC.
Okay, there's no willful violation. Yes, what do you have to say?
Your lordship, Now, Your Lordship, that communication has been sent to the Finance Department since 7/7/2023.
16 May 23, annexure 2, page 11.
In Annexure 4, my lord, only for that it has been, because pension paper is already been submitted to the AG, my lord, in Annexure 4, and they have making an objection that initial pay statement IPS of 2017 has not been fixed and approved by the pay revision, my lord, department. So
you finish it, then we will.
No, it is under process, my lord. It will be completed within very short time.
Contempt. We'll keep it pending.
Yes,
An affidavit has been filed by the respondent in showing that there has been no willful violation of the order, but that the process is still underway.
From the pay revision department.
Yes, it's still underway, as there is some hiccups with regard to the
Approval of the initial
approval
pay
of the
statement
initial pay statement of
before the Finance Department pay revision.
some hiccup with regard to the pay revision statement. So, this is matter of 2 weeks. You finish it off after 2 weeks.
No, my lord, it may be disposed. It will
No,
be
no, no, we won't dispose it. Otherwise, you'll just sleep on it.
Much.
Item number 6.
Wait, please, Your Lordship. Your Lordship, I'm praying for 1 week's time to file the affidavit on behalf of respondents 1 to 6.
Your Lordship, I'm appearing for respondent number 7 late. I'm also praying for 1 week time to file our affidavit.
How many times will take it?
A number of times, Your Lordship.
Since August. No, before that also. Ms. Hassan's appearing here. This has been too long. Instructions have been received.
Yes, Your Lordship.
Then
The
why?
affidavit has been prepared, Your Lordship. We've sent it to the department for vetting. We require 1 week's time, Your Lordship.
Though repeated opportunity been granted for filing affidavit to the response 1 to 6, to state response 1 to 6, the prior respondents 7 and 8, till date the same have not been filed. Stop. Final opportunity of 2 weeks is granted. So understood, next year affidavit should be on board. List after 2 weeks, yes.
Obliged, Your Lordship.
7.
Lordship, earlier order was passed to take a fresh step. So due to miscommunication with the petitioner, we could not take the step. Lordship, I will take the step today itself.
Okay, let us petitioner
As the Sohoria.
please allow further time to take steps, fresh steps for issuance of rules for upon response 4 and 5. Prayer is allowed this after 2 weeks.
Much obliged.
8.
Please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file my affidavit, Your Lordship.
You already, how many times you took?
3 to 4 times, Your Lordship.
You're not filing.
Your Lordship, we are praying for 3 weeks' time
For what?
for our senior counsel, conducting counsel for the petitioner.
They're asking for time. Why are you asking for time?
I mean,
You listen
from
to
the
what he's saying. Listen carefully. Yes, MS S. Salam prays for that for 2 weeks' time to file the test thereafter. Praise for very good. Yes, recorded. P. Agarwal for sworn number 2.
9.
Yes.
I am appealing for respondent number 5 and 6.
Yes.
We need 2 weeks
Affidavit.
time to file the affidavit.
Raji. Further 2 weeks' time granted to the response 1 to 4 represented by MS N. Raji and 5 and 6 by Nifty Council, Mr. V.K. Jindal for affidavits. List thereafter also.
10.
Lordship, here petitioner was required to file an application
Yes, Your Lordship. We need 3 weeks time for that also, Your Lordship.
For striking off?
Yes, Your Lordship.
And thereafter I will file the affidavit also.
Mr. Datta is not well.
No, Your Lordship.
Yes, counsel will pray that they be allowed further time to file the application for striking out respondents 3 to 10, which is granted. Stop. What about a short affidavit?
Your Lordship, I will be filing because I don't know how many respondents will remain.
Yes, Mr. Vikijan submits that after the application is filed, the short affidavit will be filed accordingly. Just after 3 weeks. Will be all right by then?
11.
Yes.
Your Lordship, I have received the affidavit, Your Lordship. Now I'm praying for 2 weeks time, Your Lordship, to seek instruction, Your Lordship.
Lord, on the basis of my affidavit, the writ petition can be disposed of. But as far as the prayer is concerned, Lordships may kindly have page 15 of the petition.
15.
Page 15, my lord. Last paragraph.
Yes.
Look, middle of the paragraph, my lord.
Yes.
To direct the respondent number 2 to comply with the direction of the judgment and order dated so and so, passed in writ petition number so and so and so on. So,
Yes.
by way of the affidavit, as directed by your lordships, my affidavit dated, my lord, 13th October 2023, my lord.
Yes.
At page 4, my lord.
Page 4.
Page 4, my lord. This is an office order issued by the Shillong Municipal Board. My
No,
affidavit,
page 4 is the verification. Page 5.
I'm so sorry, my lord.
Yes, yes.
I'm so sorry. Page 5, my lord.
Yes.
So in terms of the order passed in the writ petitions, my lord, 2 writ petitions.
Yes, Mr. Nyota, what
Nothing
remains?
survives, my lord.
Your Lordship, I'll just pray for 2 weeks time, Your Lordship, to seek instruction, Your Lordship.
Instructions for what?
Regarding with this order,
your
Your Lordship.
prayer. Okay, take out your prayer. What does your prayer say?
Yes, Your Lordship, to comply
What
with
does
the
your
order,
prayer
Your
say?
Lordship.
Your prayer
But,
says?
But we never know, Your Lordship, this
You never know?
order. Yes, Your Lordship.
See,
That's why, Your Lordship, I need
to
some
direct to comply direction judgment order dated 8/12/2020, passed within bench of the court in 318 and 371. Now, what does it say? In compliance of judgment of the High Court dated 8/12/2020 in writ petition number so and so, the gratuity shall be henceforth calculated as per the provision of so and so for all employees retired since 30th June. So,
Your Lordship, I'll just pray 1 week time, Your Lordship.
1 week time for what?
For instruction, Your Lordship, regarding with this.
See, you direct to comply. So that they say on compliance.
Yes, Your Lordship, but we don't know, Your Lordship, regarding with this, Your Lordship. That's why, Your Lordship, we wanted to talk to our client, Your Lordship. So please, can you give me one time?
Give him time, yes. Affidavit has been filed on behalf of the respondents number
Number 2.
which indicates that which at annexure 1 thereof indicates which that contains an office order dated 19 January 2021 indicating that the order dated 8/12/2020 passed writ petition number 318 of 2017 and 371 2014 have been complied with. Mr. Nyota, please follow 1 week's time to seek instructions from the petitioner. Yes, thereafter.
All right.
12.
My lord, I've received an instruction that the respondent number 2 also they will be represented.
I don't understand. What do you say?
The service of notice regarding the respondent number 2 has already completed since they have already appeared.
Number 3 is 1.
1 and 2, Your Lordship.
1 and 2. 2, you are appearing for number 2 also, Mr. Nath?
Yes, my lord. I've already filed my power.
You file affidavit.
No, affidavit, I need some.
What is this matter? No.
It's about the illegal removal of the post of headman, Your Lordship.
The sort of registered body, the sort of
No, Your Lordship, it's not a registered body. But they are the villages of.
Let them submit.
They are the villages of the Mau Village now, because the removal of the headman has not been approved by all the villages of the said village.
Let them file affidavit then.
One more, Your Lordship, I pray that I may be allowed to file this case to bring some documents, because pendency of this writ, they have filed a legal notice to hand over the keys and the seal of the Dorbars now, Your Lordship.
Do one thing, you file additional affidavit.
Yes, Your Lordship.
Yes, Mr. H.R. Nath submits that he'll be representing both respondents number 1 and 2, and prays him allowed how much time? 2 weeks time to file affidavit. What about number 3? Where's the district council? Not necessary.
Necessary parties. Your Lordship, I was informed that Senior Counsel Mr. Kanta is engaged in some program.
Program?
Yes. So,
none is present on behalf of number 3. This after 2 weeks. Mr. Khanongbak, the next paragraph, prays that allowed to file additional affidavit to bring on record further developments. Prayer granted. This after 2 weeks.
thank you.
May I please, Your Lordship? Your Lordship, in this matter, I humbly pray 2 weeks' time, Your Lordship, to obtain.
No, you're supposed to get instructions. What's the matter about?
Regarding Gambura, Your Lordship.
Regarding?
Gambura, the statement office.
Gangbura.
Post, yes.
You said Gangbura. Yes, sir. When can you get instructions?
2 weeks' time, Your
By
Lordship.
Monday.
2 weeks' time, Your Lordship.
Ms. M.S.N. Raji, they file affidavit. Ms. Raji submits that instructions not received. She prays for further weeks' time. Prayers allowed. This matter 2 weeks for affidavit, instruction stroke affidavit.
Oblige, Your Lordship.
14.
Lordship, we are yet to receive Parro's comments on this. Your Lordship. This is
Number 4?
Yep. Number 4.
During appearance on behalf of respondent before.
Give me your name again.
L. Arang, Lordship.
L. Arang, yes. Mr. L. Arang has entered appearance on behalf of respondent before, and the such service and all respondents is complete. Then for MS Yang in AG, praise has allowed further time. Further how much time?
2 weeks' time.
2 weeks, 3 weeks time to obtain instructions and to file affidavit. Similar prayer made by the newly by Mr. L. Arang. This matter of 3 weeks. Yes.
15.
Well, this is the tender matter, my lord, where the consortium partner, first partner is the petitioner, my lord, and the second consortium partner is respondent number 2, my lord. Now, my lord, we have come up with an application today, my lord, that is MC 215, my lord, for transposing the respondent number 2. This is a joint application by respondent number 2 and the petitioner, my lord.
My lord, I would like to file reply to the application, my lord, because this application is not maintainable. I can show from the person who has filed is not authorized to file it, my lord.
May I just point out, my lord?
No, miss case.
Miss case number 215, my lord.
Yes.
At page 2, my lord, this is a joint application now by Aprava Energy Private Limited and PCITS Private Limited.
You draw and file jointly, solve all the problems.
But only difficulty, my lord, it will consume some time because.
What consume time? It will consume time, will file replies, and by the time you have argument on that miscase, you know, your whole case will be diluted.
Because what happened, my lord? Otherwise, no pleading, prayer remains the same, my lord. Pleading and prayer remains the same, my lord. Only
Miss MC number 215/2023, stop. This application has been filed by the petitioner for transposition of the applicant number 2, capital BCITS, Private Limited, as a co-petitioner in instant petition. However, Mr. A. Kumar, learned senior counsel for the respondent corporation, has raised objections and praised that we be permitted to file a objection, file a reply to the base case.
But my lord, I am the dominus litis, my lord. It is my prerogative to implead someone as a
This is a matter after 1 week. Yes. Let the reply be on board. Let me decide.
Supplementary list item number 3.
My lord, this is a case where I'm aggrieved by the ex parte interim order, where I was restrained from collecting rent and interfering. In fact, I'm in possession of the stored premises. I'm collecting them till date.
What do you want today?
I'm just entering adherence today.
On behalf of the respondent. We listed after 1 week for the petition hearing, okay?
My lord, in fact, it can be remanded back with till giving me.
Is it ready? You ready? No. Give him a chance, Mr. Suna. Don't have to be so brutal.
My lord.
Yes.
Because, my lord, I'm concerned only with that collection of rent, otherwise.
Only collection of rent. Yes, Mr. Suna, that on behalf of respondent, on behalf of sole respondent, correct? A such service complete. Declares the matter listed for elevation for action hearing. This is a matter for action hearing. After 1 week, status quo order shall continue till the next day.
My duly obliged.
Hearing item number 4.
Please.
Why give a supplementary list for salary?
Yes, for relation of salary.
Lordship, the main matter is also listed today. Lordship, we can finish the matter today.
Your Lordship, I'm coming here for only for this case, Lordship, today.
No, Lordship, he has to prove his legitimacy to the petition first.
He has to prove what?
For his right towards a post, Lordship.
You ready with the hearing?
No, Your Lordship, actually only for coming for a miscase petition, Your Lordship.
Lordship, there's an order of status quo order by the school, Lordship, and we'll be taking adjournments again and again, Lordship.
There's an order?
Status quo order of the school. Saying that the termination.
See, Mr. Hiyata, you'd be fair then. Since when you haven't been paid?
No, since November 22, Your Lordship, I haven't received.
So you have to suffer for another 2 weeks maybe. You prepare the matter.
But you should at least consider this.
No, but he's right. If we are laying claim to the post and if the substantive matter is ready for hearing, should be ready. We can't have piecemeal because you don't want to complicate issues. Okay, that's the thing. Yes, and this case numbers 2 and 3 of 2023. And this application has been filed with a prayer for release of salaries of the petitioner, which he alleges has been pending since November 2022. So, next paragraph, Mr. H. Karnalang, Learned Counsel for the response submits that the main matter with regard to the petitioner's right to hold the post is ready for hearing, and that he's ready with the matter for hearing. However, Mr. Next paragraph has expressed some difficulty because this is a matter for final hearing along with the main case on
2 weeks.
After 2 weeks, yes.
All right.
Hearing 26.
TV.
26.
I'm sorry, we can't mention it's already the matter's over, please. Sorry, Mr. Counsel. Yes. Don't mention in the middle. Yes. Who's for the petitioner?
26.
Mr. Khera.
Please, Your Lordship. Lordship, conducting counsel is sick. Your Lordship, he's not well. He's down with fever.
Lordship, here I have to place
Also, I'm under medication. I'm having high fever.
Lordship, here.
Eventuality, Lordship, they had to file an affidavit to bring on record the process.
Lordship, it's not an affidavit, Lordship.
It's okay, we'll have it next day. She's brought the documents. Yes, as directed by order dated 29/2023, MSP Bharat council respondent has produced materials to substantiate the amounts on which that have been generated in the summons. However, as Mr. N. Khera is indisposed, this is matter on when? After 2 weeks. Yes.
I let it come after 3 weeks, Lordship.
Why?
2 weeks.
You're traveling.
Yes, Lordship, I'm traveling.
Okay, because this could only be there next week.
27.
Okay, 3 weeks.
Hello, Lordship.
My lord, I pray that the matter be, because I am also not well, my lord.
You're looking fit and fine.
My lord, I was there, my lord. I could not be able to, a week's time, my lord.
You're fit and fine now. What is this?
My lord,
they said, and there's a stay order.
Oh, that's why he's doing tactical adjournment.
It is not that, my lord.
Right.
It's not that, my lord.
Yes. Mr. Arjas prays that the matter be adjourned as he's not feeling well today. In the interest of justice, though objected to by Dr. Mbozika, this is matter after 2 weeks. Yes.